My name is Tesseltje de Lange, like you said. I'm from Amsterdam, and I do anything that comes with migration. At the university, mainly, I started out as a migration lawyer myself, practicing. I've been an honorary district judge doing migration cases, and I ended up doing research, but I just said to Joe Antoons, who was here this morning, that when I'm done with research, I might actually go back into practice. So, to make it a full circle. And on topic-wise, I think my work sort of goes full circle today, because my first publication on migration law was actually on fraudulent marriages and how to prove that something is a fraudulent marriage. And I might actually get back to that topic just briefly, because what it does illustrate is that fraudulence is one issue when we talk about family migration that is at the tip of the tongue of the administration working on family migration. While if we look at the impressive documents that you guys have come up with the fitness check and the other recent reports, clearly the people who are using these directives have other issues at the fore of their mind than whether it's fraudulent what they're doing, yes or no. So there's this dichotomy between whether it's fraud and looking at that bit, and whether it's exercising rights, because family migration, reunification is a right, and that is something that we cannot forget, and that makes the EU acquis on family migration so much stronger and very, very, very specific, also if you compare it to the Article 8 of the Convention on Human Rights, which has room for derogations, while when we look at the Family Reunification Directive, which will be central to my presentation, we're talking about a right. Okay, so I have slides, so I'll take you through them. You'll get them. I might want to make some little adjustments as I go along, so I'll make those tonight, and then you'll shortly have them. It's sunny outside. It's afternoon. You've had a good lunch, and you still have a couple of hours to go. Think of the ones you love. Just. It's always fun to think of the ones you love, so that doesn't hurt. But realize that what I'll be talking about is exactly that. Some people can only think about the ones they love, but it might take some time before they actually see them. Or the ones they love, they might be together, but the ones they love might not be very happy because they can't be involved in what they want to be involved in. So you have grudgy ones you love home at night saying, well, thank you, nice that you've had a nice time at the office. I'm sitting at home, not allowed to work, waiting for whatever it is I'm waiting for. I don't know really what I'm waiting for. There's a lot of insecurity when it comes to the position of family members of third country nationals who are in the EU. Just as an introduction and to get you into the mode of the people we're talking about. Challenges that I want to discuss. Just some general background, and then I want to talk about family. I want to talk about integration and labor market access, and the topic I just mentioned, I want to talk about fraud in relation to the withdrawal of residence permits. Now, I'm touching on some of the case law that will be discussed later by Anil. So if you think I'm sort of doing it too thin, then you're right. I'm doing that on purpose because I don't want to take away Anil's story. And he's much better than me on going into the nitty-gritty detail of case law. Family reunification. Why is it a right? Because we believe it helps integration and stability in society. It is very important to keep that in mind whenever you do a family migration case for whoever that is our the basis from which we depart when we talk about family migration. I think a lot of people in the administration might not get this on their first day on the team of family migration, that this is what they're doing, that they are working on helping integration and working on stability in our society. No, they're probably trained to flesh out fraudulent cases. So the mindset here, somebody has to do it. So it's up to you to have that clear mindset. And also taken from the annexes. Like Fabian said this morning, read the annexes to the fitness check. They're lovely. It's a lot of text, I agree, but I really love them, and I'm taking, you refer to number 5, Annex 5. I've been focusing on Annex 7. Somehow I don't know, it did something to me. So I have some, some references to Annex 7 specifically, and this is an example. Research consistently documents that negative and persistent effects of separation from immediate family members on the health and well-being of immigrant adults and their children, and therefore their overall integration outcomes. Being together with the ones you love helps. It helps us do what we like to do, and it helps us flourish. And if we're worried about them because they're still either in a war zone or otherwise trying to cope on their own somewhere across the world, we worry, and we just don't function as good as we could. This is a couple that runs a Eritrean restaurant in The Hague, and they're happy. And they make lovely food. I had it last night, so this picture was from last night. So whenever you're in The Hague, let me know, and then I'll refer you to them and make them even more happy as they appear here. So the framework, general, and actually incomplete, because I guess I should have started with the EU Charter or even the convention. But just to focus on the directives, the Family Reunification Directive I've mentioned, and all the other directives that we'll be discussing have, to some extent, more or less, impact on family migration and might derogate positively, mostly, not always, when it comes, for instance, to students and seasonal workers, from the Family Reunification Directive. When I mean positive derogation, I mean that it facilitates family migration more, and that family migrants, like the spouse of a blue card holder, have more rights than only the Family Reunification Directive gives them, or the limitation of rights for the spouse that are in the Family Reunification Directive don't apply, or apply to a lesser extent, under the blue card and ICT. A directive, although Fabian referred to the overall, and there was some questions also, like couldn't we have like the book on EU migration law, including maybe asylum? Then I think we need from here to the back of the room and back on paper to really capture it all. But I'll briefly touch on the Qualification Directive and the rights of those receiving subsidiary protection and or refugee status as well. And I'm actually taking them in one, although of course the Family Reunification Directive only gives rights to those, or improved rights to those who have a refugee status, but as we have seen in practice, member states combine them. So then there's not the difference between the refugee or those receiving subsidiary protection in the member states. But on the EU level, we still make that difference. And I guess that's one of the issues that might need to change in the future. Okay, so from the fitness check, again, my favorite Annex 7, I've taken 4 key concerns that have been mentioned on family migration, but there's more, but at least these 4: the difficulty to prove family ties, the pre-integration conditions, and I immediately added hinder integration, because there is, and now I see I didn't add the exact source, there is one sentence somewhere in this annex where it actually says that that is the conclusion, and that's right. There is plenty of research to go around to show that pre-integration means it takes longer to be able to unite, and hence it takes longer for the one who's already here to integrate. So pre-integration conditions at least hinder the integration of the person already in the EU, because they're without their loved ones. You could argue, and that is what the court has done so far, saying, well, it makes sense for the people coming in that you know a little bit about the language and about the country you're going to. So far, yes, I think it does make sense, but because it takes time, because of the costs, because of a lot of barriers involved, this could possibly also mean that the pre-integration conditions hinder the integration of the family member. But that is maybe a question from me also to Fabian to elaborate on. Long processing time, it's been mentioned before, and that goes for family members as well. If the sponsor is allowed in, is working, and the family member cannot join, or they can join but they have to await for the outcome of their application procedure, and in the meantime they're sitting at home being grudgy. Because they cannot work, they cannot pick up their own career. That's something of concern. And the fees have been mentioned just now, so I think we might, in the question round, we might need to talk about some money stuff. Okay, proof of family ties. I've listed a couple of things that are going on with this regard. Foster children, the directive mentions adoption. That's our Western definition of adoption, that's accepted. But then, of course, there's always a different situation. And then you have the situation of kafala, which is the alternative, you could say Islamic alternative to our adoption, practiced in many Arabic, Middle Eastern, Northern African countries. One case that I mention here from the Committee on the Rights of the Child of November last year deals with such a situation. It's actually a Belgium case. Somehow the Belgians have something with children. I don't know. That's maybe not the only thing they have something with. But again, a child. This time the child wasn't here, but the child was in Morocco and adopted under the legal regime of the kafala. Taken care of by two Belgian people in Morocco, but they also had former and hence still Moroccan nationality, because it's something you cannot easily get rid of. And the debate was on whether family reunification was possible one way or another. They tried different sorts of visa. They tried temporary visa. They tried one way or another, the Belgian authorities said, no, you're not getting this visa because the child is not yours. Or, by the way, looks like you're doing fine in Morocco taking care of the child. So the husband was here working, the wife was there with the child, which they were taking care of. It was assigned to them, but they adopted it, they were responsible for it. So they had this, I think, 5 years split family situation, and of that, the Committee on the Rights of the Child said, come on, guys, this is not in the best interest of the child, and that is their frame of reference. And actually, we have, before the European Court, a more or less similar question pending, from a UK case, where it also deals with the question on whether how we should read kafala and whether we should treat it similarly as adoption, or at least allow family reunification, family ties to be defined through this legal instrument, yes or no. Another issue has to do with surrogate mothers. That's also a lot of, it's big business, for one. There's a lot of people at least considering it or using it, and there's been some case law on what it does. What kind of relation comes about when you and your partner don't have the child together, but it is a surrogate mom who has the child. And so far, the European Court of Human Rights has said that this does create private life, but not family life. There's a lot more to be said about it. I'm just touching on it as one of the topics on where you can see struggles in practice and where I expect more struggles to be coming up as our lives are becoming more cyborg-like and surrogate motherhood, well, it's not cyborg, but it is different from the more traditional way of getting a child, and stepping out of the traditional ideas of family, familyhood, family creation is exactly what's happening out there, and the law is, as law often does, sort of following behind a couple of years, trying to grasp what this development does for rights and obligations of people. Same-sex partners has been a topic, at least in the Netherlands already since the 80s. But not everybody is up to speed as in accepting same-sex relationships. So that is also a topic that has been on the table of the European Court. And if I'm not mistaken, Anil will discuss the Coleman case later. Parents of adults, there's also, like in the directive, it's always, we have the core family, and then paragraph 2 says, well, member states may expand to allow for other family members, which could include your parents if they're dependent on you. And then, of course, the question is, when is someone dependent, etc. So this is also partly addressed in the guidelines explaining how to apply the Family Reunification Directive. Here I list at least 3, but it's more I've learned from the implementation report. More countries that do not allow parents in. And Italy, for instance, I read, only allows the parent of the main sponsor in and not of the spouse. So then the spouse has to become a main sponsor, I would think, and then you could still, but it's complicated. So there's, again, it's not straightforward in all countries. Multiple parenthood. You don't have to answer because of privacy laws. Anybody divorced and remarried? Have children with your first and your second husband? And want your second husband to be, legally speaking, a father of the children you had from your first husband, who has run away with some young broad and you don't want to see him anymore? Yeah. It's a no-go, right? You can only have 2 parents. Snap out of it. That's it. But in reality, there's a lot of families where this second father is much more of a father than the first one. So why can't this second father legally be the father? And if he dies, have your kids inherit his stuff and whatever. We don't have that. You have 2 parents. That's it. Again, the Netherlands, somehow we sort of like to expand on these things. There was a report 2 years ago saying, okay, let's work out multiple parenthood. You also have it with gay couples who have a child with a mother who is not necessarily a surrogate mother, but who wants to be part of this parenthood. So you have 3 parents. Why not? But what if one of the 3 is a migrant? And the other one somewhere is a third country national staying here. And who then gets what resident right? You don't. We only allow for core families with 1 parent. But in reality, out there, there's mixed families of all shapes and sizes. With the advisory committee that I'm on, and we're giving independent advice to the Dutch government, we just drafted a report with some ideas of how you could design a migration policy to allow for multiple parents beyond the 2. So if family law in the Netherlands changes, migration law has to follow and allow for this multiple parenthood. So if you have this multiple with a third country national, then the future might be in the Netherlands for you. But how to prove these family ties? DNA testing has been on the hot topic list of a lot of people recently. But there's a mix of ways to prove how the family is constituted. Let me ask you a question. When you were 5, did you have full-time access to electricity? And most of you grew up in, I don't know, Europe? I don't know, and you're all very young. So I think we, on average, had electricity all night long. But what if a girl from Somalia says, no, the electricity always shut off at 8? That can't be true, because we know for a fact that where she was living, there were no problems with electricity at the time she's talking of. But do we trust a child's story of what was, maybe this child wasn't actually living with the parents, because the parents didn't say anything about electricity shutting down at 8 o'clock by standards. So what's going on? There's somebody lying here, so let's not trust it. There's no family relationship here, because the child says the light went out at 8. Period. Yeah, so the mother switched off the light at 8 because the child had to go to bed, right? So what a child's perception is of what the reality is during the childhood, you have to be really careful in reading anything in it and concluding that that means that she wasn't living together with the parents at the time. But it's happening. The interviewing of children, when it comes to cases, especially also in relation to, say, the minors who come here on their own, apply for asylum, and then ask for family reunification, how to prove who is part of a family and how this is done. Interviews are, to my knowledge, not taped, at least not in the Netherlands. Anybody ever heard of these interviews being taped as, or even filmed? Because then you can see the body language. You can learn so much more from. It's not being done. It's just transcripts by officials who make such transcripts on a daily basis. So the language of the child, which is probably already thin, is transformed into administrative language in the transcripts, which is repeatedly done by the officials. So you sort of use the same words, because that's what you do when you use the same words all the time. So what is true of what these reports say? And then we base a whole family's life on such documentation. Even if there is DNA to prove for a family tie, it has happened that the DNA has been rejected as evidence because these other stories don't add up. So there's, and that of course is typically painful in situations where it concerns refugees and those receiving protection. Bottom line from the European Court of Justice is, of course, that assessment has to be on an individual basis. And you must consider the situation of the family and not just base your story or your negative decision on general info from the country of origin. They did good on electricity, so the story can't be true, so end of story. No, there has to be more to it. And I sort of read, when you read case law, I like to draw. I like to draw out the timelines, because although this case is not about integration, if you draw out the timeline, this case was a mom who came with her child and left her foster child behind, and then in 2000, you can't see, you'll see later on. 2013, she left Eritrea, she was in Sudan for some time. 2015, she got subsidiary protection in, where are we, the Netherlands. In March, in April, she applied for family reunification with this child she left behind. Didn't get it. March 2019, we have a decision. So now we're back to the national procedure. All this time, she, I'm sure, is not sleeping well at night. So, because you have a child left behind somewhere in Sudan, that's not good for her integration. It's probably not good for the integration of her other child who's with her. So what are we spending our money on exactly? Because in the end, it feels like this child will eventually be able to reunite. So it is really a 5 to 10 years delay. And in that time, that child could have had education here. Instead of, and now I'm being really cynical, us spending €1 million on 30 to 60 Nigerians coming as ICT people to work in Lithuania, which we were discussing before the break, we're spending money on not giving this child the opportunity to make it. While we know they'll probably join one way or another at some time, and then we have a family that has 6, 7, 8 years of waiting to start with integration and to start building their bit of our resilient society. But that's more or less on a moral note. Let me continue. Can you see the picture? I hope not. It's a family dressed in Dutch traditional clothing in Volendam. I put the picture up here as a little bit of an illustration of the case, a Danish case, where there was also a question on how integrated is a sponsor. So we're not just talking about integration of the people who are coming, but the sponsor. And this was a Turkish case. So of course, when we talk about Turkish migrants, immediately the association treaty with the EEC and Turkey comes to life, and in this case, Decision 180, which has a standstill clause saying, freeze the law as it was in about 1980 with regard to the rights of migrants. And here, the Danish requirement of connectedness is at stake. And the conclusion from the Advocate General was that connectedness is a new requirement, not justifiable, and hence shouldn't be applied. And I was just wondering how connected should you be? I mean, should you be, if this would be a Dutch case, wearing on a regular basis these outfits, then a lot of people wouldn't pass the test of being properly connected. But I think Anil, and I think you came in, you will talk about the case as well, the Danish one. On no, it's not in you. Okay, so you'll have to do with this, and just remember, and I'll just give it, it's me with my family. So you can figure out what the construction is, who's what to what. Okay, let me continue. How am I on time? Doing okay, good. I'm going to my second topic. So I've talked a little bit about who's the family and about proving family and about family and connectedness to the country of origin. Now I'm switching to the topic of labor market integration, participation of family, and what about that? There is an equal right to access of the labor market for family members, but in practice we see there's plenty of data that you see that people with a migration background are not yet fully, are not able to fully participate on the labor market in most EU countries, although for the Netherlands we had a very positive report yesterday in one of the newspapers saying that the Dutch Moroccans had risen to the top of being participating in the labor market and integrating, while they were always sort of like at the bottom in the statistics. That's something. I have a couple of questions. Maybe Fabian can address them, or we have to discuss them over drinks later on. But one of the things that really bothers me is although there is a legal right to work for spouses, it is not necessarily facilitated. And if I look to people who are receiving protection and their family members, there are rights to integration, or at least member states have to give access to integration programs, they have to give access to employment and self-employment, but there is no obligation to do more than just give access. And I'm really curious to see where we can go to actually be more active in facilitating this, because there's a lot of things that actually work against labor market integration instead of facilitating it. It goes for those receiving protection. It also goes for those who come with a migrant worker, be it a blue card, ICT, etc. Dual career policies are not, there's been some mention of on dual career policies in previous documents. I didn't find it in the documents this time, but it is really an issue that somebody should be working on. The question is who? Is it the migrant's responsibility? Is it the EU's responsibility, member states, municipality, private sector? Who should take care of assisting partners in getting access to jobs? You may have free access to the labor market, but that in practice just doesn't do it. Okay, the final topic, 1 minute. I can do it in 1 minute because I know that Anil will be discussing part of the case law that I'm mentioning. Like I said at the beginning, no, this doesn't work. Member states have a focus on trying to find family members who are fraudulent. That's a focus. We don't want to give a status to somebody who's being a fraud. And there have been examples of people playing with the rules, so okay, it makes sense to some extent to look at it. But the consequences might again not necessarily work out positively. There is a right to withdraw permits if somebody is a fraud, has been acting fraudulent. There's also a right to withdraw if the conditions for residence permit are no longer satisfied. It makes sense, but I want to focus on the first para and hear your thoughts on this. If the family, so this is, and I'm going to wrap up with this example. Highly skilled worker working with a recognized sponsor in the Dutch case, and then the recognized sponsor messes up. They make a mess of their administration. They change legal entities, etc. And then, you know, HR sends a letter to the workers, including a migrant worker, saying, don't worry, you know, nothing's changed. We're just going from one legal entity to the other. You don't need to do anything about this. And then the migrant, of course, doesn't do anything about this. But what appears to be the case is that this legal entity, the first one was a recognized sponsor, the second one isn't. So in 4 months' time, this migrant has been working for a non-recognized sponsor, which is actually illegal employment in the Netherlands. So what can you do? You can sanction the sponsor. There's a whole heap of sanctions that you give, and the directives also say that there should be effective sanctions in place if the sponsors are not doing what they're supposed to do. But the Dutch government doesn't sanction the employer. They just withdraw the residence permit retrospectively to the moment of the change from the legal entities of the worker and of the family members, because the family members, of course, also no longer satisfy the conditions for residence, because the sponsor is no longer a worker, but an illegally employed migrant. So they all lose out. The children were in school for 4.5 years. They were almost long-term residents. They were planning to apply. They had saved up the money that they needed. It all stopped, and they eventually got new residence permits a couple of months later, but they had their gap and had to go another 5 years. They didn't challenge this because they, in the end, got what they re-got their residence permit, which I think was a bummer. I mean, I would have loved to challenge and ask, how does this fit with the long-term residence permit and the right to build up a permanent residence? Because there were other ways to sanction this situation. There were other ways to solve it than take away their rights. And there was no consideration of the right of the child or the right of the wife and their private life that they had built up in the Netherlands. They were not considered. The focus was on the working husband and on the husband's relationship with the business. There were 3 of these cases in the Netherlands, and there's a lot more of them that just don't go to court. So hopefully there will soon. So we'll have more case law for Anil to discuss in the future, and for you to study as well, and for us to enjoy reading. And I think I'll wrap up with that and look forward to Fabian's comments, suggestions, and your questions. Thank you very much.